Hi, my name is John Garvin. I am the president and founder of benicoltd, an employee benefits consulting firm based in the far northwest suburbs of Chicago. We are pleased to present this video about the Family and Medical Leave Act, commonly referred to as FMLA, as one in a series of videos we have produced around employee benefit concepts and ideas of interest to owners and managers of businesses of all sizes. As a small business owner, you've probably realized success depends on anticipating and managing the various risks and opportunities that confront your venture. You've envisioned a number of these scenarios and your responses to them in your business plan. You've given extensive thought to your marketing and sales, manufacturing, and purchasing strategies, but what about your HR strategy? The Family and Medical Leave Act, FMLA, of 1993 is one of many regulations that makes it imperative for small business owners to consider human resources in a different light to avoid losing expensive lawsuits, alienating your workforce, and distracting your attention. FMLA, a workplace law in the domain of the United States Department of Labor, requires companies that employ a workforce of 50 or more, or that are public agencies, to make unpaid leave of up to 12 weeks available to employees facing personal medical problems, the birth or adoption of a child, or the need to care for a family member. FMLA applies specifically to employees who have worked for your company for at least 12 months and 1,250 hours, and who intend to return to work at the conclusion of their leave. You must continue to pay the benefits of these employees and save their jobs for them. The costs of compliance with FMLA, frankly, are high. In fact, the Small Business Administration estimates that small businesses spend about $6.3 billion a year on compliance, averaging $31,000 per eligible small business. Fortunately, though, it is possible to minimize this cost by understanding what FMLA requires you to do. So there's a number of things you can do in terms of an action list. The first one would be consult the Department of Labor's resources on FMLA and refer to the text of the regulation to clear up any lingering questions. Second, be sure to alert your employees to the existence of FMLA via workplace posters or other methods. Third, provide detailed written explanations of your human resources policy, including FMLA clauses, to new and prospective employees. Fourth, know that employees can apply for FMLA leave on the basis of many possible medical and family-related scenarios, including reasons of personal mental health. It is ultimately up to the employee and not to you to decide which reasons are legitimate for FMLA leave purposes. Fifth, never fire, demote, or otherwise discriminate against a returning FMLA employee because of their leave. FMLA guarantees employees the right to return to their existing jobs under existing conditions. Sixth, be aware that the statute of limitations regarding the FMLA is 2 or 3 years depending on the situation. This means that an employee can file a grievance long after an FMLA leave has concluded. Seventh, know your own rights. As an employer, you can require FMLA leave applicants to substitute paid leave if available in place of some or all of the FMLA time. Eighth, when your company grows, hire a human resources specialist to help craft and enforce policies for your expanding workforce, and make certain that he or she is familiar with FMLA laws and local rulings, as well as with other workplace laws and regulations. And ninth, finally, in many cases it makes perfect sense to outsource your FMLA administration to a third party. To this end, many of the insurance companies that administer group disability benefits also offer services around FMLA administration that oftentimes integrates their disability benefit administration with FMLA. Business owners should be aware that courts have repeatedly demonstrated a willingness to err on the side of the employee in FMLA disputes. For example, in Stevenson versus Hire Electric Company, the court ruled on behalf of a stressed-out employee who had been fired as a result of acting oddly at work and calling in sick several days in a row. Although this employee did not officially file for FMLA, the court decided that her behavior alone constituted a notice of FMLA leave. Also in Honolulu, a court decided that an employee who had been demoted after returning from FMLA leave had been illegally discriminated against, even though the employer claimed that the demotion resulted from budgetary reasons. These kinds of cases demonstrate not only the employee's wiggle room under FMLA, but also how employers who act in good faith can still be penalized under the regulation. While FMLA is open to abuse, the purpose of the law is commendable, and that is to ensure that employees are able to secure their own and their family's mental and physical health without being penalized. Well, that concludes our overview about FMLA. If you have any further questions about the subject or would like to consult with an employee benefits professional about how to incorporate FMLA management into your overall benefits strategy and HR strategy, please give us a call at 847-669-4800. We're glad you joined us today, and we hope you'll take the opportunity soon to view the other videos in our series around employee benefit concepts and ideas of interest to owners and managers of businesses. Bye for now.